So in the world of cleaner, greener, safer and smarter transportation, we generally cover the vehicles themselves, the fuel sources that those vehicles use. And yes, sometimes we cover renewable energy and clean energy products as well, be it energy storage or some other kind of clean energy product, whether it is solar panels, whether it's wind turbines, or whether it's better ways of using the materials that we have in the world around us to generate energy. But today, I'm doing a first on this channel. It's never happened before, but I've got a gentleman on because over the last couple of weeks, in fact, over the last couple of years, there's been an ongoing legal battle in the clean vehicle space. You'll notice I don't say electric here. That is because this is a battle between two massive players in the big rig truck world. On one side, we've got Nikola Motors, and on the other side, we've got Tesla Motors. We've got Nikola versus Tesla, the Nikola-Tesla battle. I don't know what you want to call it. There are so many puns and so many jokes that you can make on that. But basically, the 50,000-foot layperson's view of this is that Nikola came along and said, hey, we've got this hydrogen fuel cell big rig that we are going to make, and it's going to make it possible for goods and all these things to be shipped around big countries like the US using zero tailpipe emissions. And then Tesla came along and said, yeah, we're going to make a big rig too, but it's not going to be hydrogen powered, it's going to be battery electric. And that is where things went, as we used to say in the UK, a bit Pete Tong. Because at that point, Nikola decided that they were going to go after Tesla with a lawsuit. I do not play a lawyer on YouTube. I'm not one in real life, but I do know a real life lawyer. Please welcome Andrew Torrez from Opening Arguments. Hi, Andrew.
Hi, thanks for having me on the show. I do indeed play a lawyer on YouTube and on my Opening Arguments podcast. And thanks for having me on. I should do, since I'm a lawyer, I should do the legal disclaimer, right?
I was hoping that you were going to. Go on.
So the motto of our show is don't take legal advice from a podcast. Nothing in this broadcast creates an attorney-client relationship or is intended to offer legal advice to any person. I'm just here chatting with my friend about the future of electronic vehicles, or electric vehicles, or I know the law. I do not know what a Class 8 truck is. I'm hoping you can enlighten me on that.
Well, it's basically a certain capacity. It can tow a certain amount of weight.
I inferred that.
The details of which is Class 8, which is whatever, is irrelevant. But most of the big rigs that you see driving coast to coast are Class 8 big rigs. So your Peterbilts, the big riggers, you know, like you see in The Simpsons, the one that Bart Simpson always tries and gets the guy to pull his horn. Those big rigs, the ones that go coast to coast, that haul huge amounts of stuff. I think 80,000 pounds is their towing, is how much they can haul. Don't quote me on that because I think it's slightly different. But the concept here is that there is an ongoing battle between, on one side, the hydrogen fuel cell electric vehicle, and on the other side, the battery electric vehicle. Both are electric vehicles. They both use electric motors to power themselves along the ground. The source of where they get their electricity from is different. On one side, you've got Nikola Motors with a hydrogen fuel cell stack, which gets its fuel from the fuel tanks inside the vehicle, and nice chemical reactions going on inside the fuel cell, and then you've got the power to the road. On the other side, you've got Tesla with its massive battery packs, its mega charging stations. Now, let's take a bit of a back step here. Now, Andrew, you work in Maryland and Washington, D.C., right?
I do.
And your daytime job is focusing in which area of law?
So I represent small businesses, and typically the area in which I work that overlaps with the lawsuit that we're going to discuss, sort of tangentially, is what lawyers would call soft IP, soft intellectual property, trademark, and copyright infringement.
So it's sort of squishy. Squishy,
exactly.
squishy trademark. I like that. I can deal with squishy.
Well, and that is contrasted with the subject matter of the lawsuit that we're going to discuss, which is patent law, which is typically called hard IP because of the unique aspects of patent law. So I should say, I am mostly aware of what patent law is to tell clients that I don't practice in this area. Most lawyers who do have an engineering background for reasons that I'm about to explain. But like it's the internet. I'm comfortable opining in an area of law in which I do not practice. So that's kind of a general summary of what I do as a lawyer on a day-to-day basis. And then, my show, obviously, we take stories in the news that have a legal component and break them down for a non-legal audience.
And you also get to play a Supreme Court judge sometimes?
Well, that was, some kids, right, when you're 12, dream of being president someday. And when I was 12, I dreamed, I still have this dream, but it seems unlikely to come true, that I was going to be Chief Justice of the Supreme Court one day. So, yes, that's part of what I do on the show, and that fulfills a long-standing childhood fantasy.
That sounds fantastic. I don't know what I dreamed of doing when I was younger. I did dream of doing, I suppose, radio and TV. So I guess I'm halfway there. So there you go. But let's get to the meat of the matter. So I'm going to show, and because of a technical problem, you can't see the video, which is a bit of a shame. But I'm going to show two pictures. So this first picture here is that is the Nikola One semi. It is an all-electric, well, hydrogen fuel cell powered, but all-electric drivetrain. It is capable of extended range per fill, and Nikola came up with this design that's very unique, or at least was at the time, for a hydrogen fuel cell vehicle. It's got a very sweeping front end. It's very aerodynamic. It doesn't look like your standard Peterbilt big rig. It looks very different. And so when they came up with this design, Nikola came up with a patent application, as I understand it. Please correct me if I'm wrong. That said, hey, we've come up with these unique design elements for a hydrogen fuel cell vehicle, and we would like to know if we can have the patent for this. Now, what normally happens with patent applications at that point?
So everything you've just said is 100% correct. And what I want to add is you were sort of setting up that the difference between the Nikola truck design and the Tesla truck design has to do with how the vehicle is powered, right? Whether it is a hydrogen hybrid versus a pure electric vehicle. That's not the subject of this lawsuit, right? So this lawsuit is entirely about 4 separate patents that were taken out by Nikola. A patent for the fuselage, for the main body of the truck, shield on the front of the truck, which you can see again. I loved your introduction, right? Like when you look at it, you think, what looks weird about this, right? What makes it look different than your standard truck on the road? Well, the body, the windshield wrapping around, the door, which I think you're going to talk about, which sort of opens backwards and is behind the driver's side seat.
Right.
And then there's a 4th patent, which is sort of how those first 3 patents are put together.
Right.
and now, right, to kind of explain the legal aspects, I would want to take a step back and talk about like the kinds of intellectual property that you can protect. Okay. And one of the things that I have to tell listeners and clients all the time is you can't protect in general, put a little asterisk by this, you can't protect an idea, right? And the example, I always use the exact same example, which is suppose, right, we know that somebody had an idea for a TV show in which people who were not professional singers would get on and would sing, and you'd have a panel of experts and they would judge, and the winner would then get a recording contract, right? And the fact that we have a dozen shows that are like that proves that that idea, that sort of concept of, hey, there ought to be a TV show in which people, sing and what, like that is not trademarkable, it's not copyrightable, it's not patentable. It's just an idea. But patent law protects, in oversimplifying here, it protects two kinds of specific ideas in U.S. law. And I should also add, to be clear, this is a lawsuit that is pending. It was moved from the U.S. District Court in Arizona to the U.S. District Court in the Northern District of California. But this is a U.S. lawsuit. I'm a U.S. lawyer, so I'm going to talk about U.S. law. So you can patent, broadly speaking, two kinds of things. You can patent designs, right? That is how something works. And you can patent, you can get a utility patent, right? So a utility patent is when you invent a process, right? The section of the U.S. code that pertains to this is 35 U.S.C. 101, which says whoever invents or discovers any new or useful process, machine, manufacture, or composition of matter, or any new or useful improvement thereof may obtain a patent. Therefore.
Right.
So, yeah.
So that's really important to note, because that means that, as you said, if somebody, you don't have to come up with a completely new idea in order to obtain a patent. You just have to be able to prove the prior patents that came along that allowed you to then build upon that, right?
Right. A new or useful improvement thereof. And a really, really good way to think about this is, where a lot of patent litigation takes place is in the pharmaceutical industry, right? And so when you think about the opioid crisis right now, which is ravaging my country, and it is a problem throughout the world, had to do with not the invention of a new kind of painkiller, but rather the invention of a kind of timed release system for existing painkillers, right? And that was, and you can patent that, right? And that's a good way of thinking about like what patent law protects. And what patent law protects is it says when you patent a design or a process, then you get the right to prevent other people from using that design or process for a limited period of time. And again, here I think the pharmaceutical industry is really instructive, right? And so you'll think about it like, oh yeah, I remember a time in which, X medication was only available in the brand name, and now is available in the generic. Why is it available in the generic? Because the initial patent has expired. Right. So that's what patenting does, is it gives you a period of exclusivity where you say, hey, I came up with this new and unique thing, and nobody else can use this new or unique thing for the time period in which that's protected by patent law.
So let's take
much
this
shorter. Right.
Oh, yeah, sorry, Andrew.
No, go right ahead.
So let's take this to where Nikola was. Okay, so Nikola came along, they had this hydrogen fuel cell truck. They'd worked really hard on the aerodynamic shape of it, that weird door that opens to the side rather than just, at the front of the cab like a regular truck. That opens up a lot more space in the inside of the truck. It changes how you can arrange the seating. It makes it more efficient and nicer place to be because there's no massive gearbox in the middle. All of those benefits. And Nikola decided to patent that as part of its process. And I think partly because of how the company is run, partly because of the way its CEO operates, they've got experience in this industry and know how it works. And so they've got this idea of, okay, we're going to patent this design. Obviously, it was very aerodynamic, designed to be very aerodynamic, so it's as efficient as possible. And so that initial patent they filed was for the design of those three things that you detailed: the front windshield, the door, the way everything works together, right?
So the three design patents are the fuselage, the body of the truck, the windshield that wraps around, and then the side door. And then the fourth patent is the utility that puts that all together.
Okay. And then, right. So they had this big unveiling. I remember when Nikola came out with this and everyone was like, wow, that's really strange and unique, but hey, that's a truck. Now, at this point, politics comes into this because the electric vehicle world, which I personally have been, completely immersed in since 2006, 2005, 2006. I know the industry pretty well. I know some of the people in it, and I know the absolute vehement hatred that exists in the electric vehicle world towards hydrogen fuel cells, or as a lot of my people like to call it, fool cells, because, for the last 20, 30 years, hydrogen fuel cell has been the fuel of the future in a few years' time for the last 20 or 30 years. And so people are very dismissive of the technology. They're very dismissive of its application in the real world. We've seen setbacks from some major OEM automakers who've tried hydrogen fuel cell technology and then run into issues with hydrogen fueling infrastructure, power density of the systems, the amount of air cooling that you need to get this to work. But nevertheless, Nikola came along with a hydrogen fuel cell powered truck. Since then, Nikola's come out with battery trucks that it's going to make alongside its hydrogen fuel cell variants. But that initial reaction, despite it being a very unique looking truck, despite it having some very unique looking figures, people's general reaction, I think, especially if they weren't covering the industry, was, well, that's not going to fly. That's hydrogen. It's not going to work. So they already kind of had the world against them, right? And shortly after they unveiled this truck, and they'd already got the patents, sometime later, Elon Musk and Tesla went, hey, we're going to build a big rig. We're going to show it to you. Here is the Tesla Semi. Guess what? The Tesla Semi has this big front windshield. It has this side opening door, almost identical profile, I'd hazard to say, that big fuselage, and a slightly different interior because they've got the front center, the driver sits in the middle of the cab rather than at either side. But that caused Nikola to come along and go, yeah, that's our design here. And thus the between the two companies began. Now, there's no love lost between these two companies. I've got both of the trucks up side by side here on screen. It does look slightly different. You could argue that Tesla's implementation is subtly different to Nikola's. Nikola's looks a little bit more like a conventional truck. Tesla's looks more futuristic, but it's clear they're built from a similar DNA. Now, Tesla, being the company that it is, the company that's helped get people into electric vehicles, it's fair to say without Tesla, I wouldn't be here doing this now, because Tesla has helped the electric vehicle industry grow and competition to spark up, and for there to be enough coverage that I can do this full time. And a lot of people really want Tesla to succeed. And so when Nikola came along with a legal challenge to Tesla's design and said, we'll see you in court, the instant reaction from the majority of electric vehicle supporters out there is, well, clearly Nikola needs to burn in hell. Which brings me from that very kind of gut-wrenching reaction from people who want Tesla to succeed. And some people support Tesla, can see it do no wrong. Other people go, okay, Tesla makes mistakes, but I still think Nikola's doing a bad thing. And other people look at it and go, well, hang on a minute, which is why I invited you on this show, Andrew, to talk about this, because I'm not a lawyer, I'm not a legal expert. You are. Talk us through these two counter arguments and this back and forth that's been going on between these two companies.
Sure. And let me kind of set the groundwork here a little bit. From a legal perspective, you evaluate a case at a couple of different points along the process. And those points correlate very strongly with how much it's going to cost to defend this lawsuit, right? So the very first level review that you look at is you ask, as a lawyer, you ask the question, is this lawsuit going to survive a motion to dismiss? And a motion to dismiss says, even if all the facts that are alleged in the lawsuit are true, you don't have a legal case against the defendant. So there's no need for discovery, which is an expensive and time-consuming process, particularly between two large corporations, right? You just go in, you get an initial ruling, this is nonsense, throw it out. And so the classic example of that is, if I were to sue you after we do this YouTube interview, and I say, you made me super duper sad during the course of this interview, right? Yeah, you would file a motion to dismiss, and you would be like, while reserving the right to contest that I made Andrew very sad, like making him sad is not a violation of U.S. law, so we move to dismiss, and you'd win, right? Because even if it's true that I hang up and I'm despondent because of how badly you've treated me and it's terrible, I don't get judgment as a matter of law on that, right? That is not a cause of action against me. So I want to tell you this. Nikola has survived a motion to dismiss from Tesla. And in fact, Tesla did not move to dismiss on 2 of the 5 counts that are in this complaint. So if that's your sort of first cut of, was this complaint written, in crayon on a napkin filed by somebody who's mentally defective? No, it's a serious complaint filed in 2018 that Tesla has been that both parties have been aggressively litigating, that has survived a motion to dismiss. So not a crank lawsuit, right? And
so let's start here with it, because the initial case was filed in Arizona. Mm-hmm. That is because Nikola Motors are based in Arizona. I've toured their facility. They are based in Phoenix, and I guess they filed locally because that's their local jurisdiction. Tesla came along and managed to get it moved to Northern California. So how does that work?
Yeah, so we have a saying in U.S. law, which is the plaintiff is master of her complaint. In order to file, so the United States, it's super weird. This goes back to 13th century Saxony. We have a federal court system, and then we also have 50 states that are sovereign, that are part of the United States. And so in order to be in a particular court, that court must have both subject matter jurisdiction and personal jurisdiction over all of the parties, right? And without going into 6 months worth of law school, because Tesla sells stuff in Arizona, and because Nikola is based in Arizona, you can sue in Arizona. Arizona has personal jurisdiction over both parties. And you go into federal court because the two parties are parties of 2 different states, and the amount in controversy is several $1 billion. It greatly exceeds the minimum, which is $75,000, which you need to be in federal court. So nothing improper about Nikola suing Tesla in Arizona. But then you get into court, and then the defendant gets the chance to say, I get it. This court in Arizona does possess the minimum jurisdictional requirements to hear this case, but this is really about what we as Tesla did in California. And so this should really be heard by a California court. And so they then moved to transfer the case to California, and they won on that, right? So they got it moved from, and again, federal court is not supposed to be, home cooking for either party, but they got it moved from Arizona to California, which can, look, this would matter a great deal if it were you or I as an individual. Probably not a huge deal for, a large, well-funded startup in Nikola and, of course, Tesla, billion-dollar company.
And so, I think the impression I get from this is, and I don't want to kind of make any assumptions here, but I guess I'm going to make an assumption that if you are the billion-dollar company that is run by a billionaire, that is well known and well supported, and you have friends in high places, and you have a crack legal team, a really fantastic legal team that are just, that you have been searching for years, you've worked with them for years, and Tesla keeps its legal counsel and looks after its legal counsel. I guess the hope is that even if technically you might be on shaky ground, you're still going to try and fight this case. Is that where Tesla is?
Yeah. So a couple of things to say there, and that dovetails really nicely with how I tell people who aren't lawyers to read a complaint. So in the American system, with a few exceptions, we do not have a loser pays system, right? We have a system whereby all parties bear their attorney's costs regardless of whether you win or lose. And again, I'm oversimplifying, but that's the baseline, what is actually called in courts the American rule, right? And so, yes, the second that you have, and by the way, I mean, Nikola is asking for $2 billion in damages in this lawsuit, right? So $2 billion is still a lot of money. Yeah, exactly. And at that point, you say, okay, there's $2 billion at issue here. If I spend $2 million on litigation, right, to protect myself from losing $2 billion, like that's pretty good trade-off, right? So instantly, and by the way, like I did this for almost 20 years, right? Like this was before going off and starting my own firm. Tesla's firm is a DC-based law firm that I know well called Latham and Watkins. I interviewed with them. I worked at a firm that was very, very similar to them for a decade, right? So high-end, high dollar value attorneys making over $1,000 an hour. And just a top-notch law firm. And yes, what you do is you litigate the hell out of your case because even a smaller company, and here, again, I wouldn't want to be sued by Nikola Corporation. I would much rather be sued by Nikola than by Tesla. Right. I mean, they're several orders of magnitude smaller. And the idea is, you just make it expensive for them to continue to litigate out this case. And so, one of the things that, we often say in the law is that, like, I can get you 95% of the way there in 100 hours. Or I can get you 99% of the way there in 1,000 hours, or I can get you 99.9% of the way there in 10,000 hours, right? And continue to scale up. And it is these multi-billion-dollar cases where the client says, spare no expense, litigate everything you can, pursue every rabbit trail, run everything to ground that's possible, because if there's some way out of us having to pay $2 billion, we'd like to find what that is, right?
And it's a really interesting. It's a really interesting thing because people, I don't think people look at it like that at the moment. And the prevalent kind of attitude. I've been reading articles and coverage from other sites who are known, we are known as being a site that tends to be quite fair to everybody. At least that's what we try to be, and I try to be as impartial as I possibly can. But at the same point, there are sites out there that are very fanboy, sort of targeted towards one particular brand, it's normally Tesla, who tend to take Tesla's side in this and go, well, clearly the other company are just trolling. And then, the CEO of the company blocks you on Twitter and all of this other stuff. I've got no skin in this either way. I'm going to be able to cover Tesla. I'm going to be able to cover these other companies. It's in my interest to keep things, nice and smooth and even. Although I should note at this point, what you said about litigation and expensive cases is the reason why I, a small business owner in Oregon, has the same insurance policy that the BBC uses. People joke at me and say, well, why is your insurance so expensive? I run my own business and I only pay $800 a year for insurance, and I'm sitting here paying nearly, I think last year it was nearly $6,000. I said, why is it so expensive? Is it because of the camera equipment? I go, no, it's because I don't want to get sued and have to pay for it out of pocket.
I did work for Lloyd's of London for over a decade, so we could go down that avenue, but right, like let me first talk about how this is very clearly not a patent troll situation, right? Like, look, those exist, and to understand how those come about, requires kind of understanding the difference between patent law and copyright law. And since I practice copyright law, like I'm actually, fully qualified to answer this question. But let me say at the outset, like I try and do the same thing you do on our show, right? I don't have a dog in this fight. I don't represent either Tesla or Nikola. I'm not likely to represent either of those companies, right? Like I just am trying to understand this particular lawsuit. Now, what are patent trolls? Patent trolls are companies that buy up patents and hire lawyers to sue other companies that are infringing upon that patent. And the reason that comes about is because of the difference in what patent law protects versus what copyright protects. So copyright protects original works of artistic merit, right? And what it protects you from is hidden right there in the name, other people copying that thing, right? And very often you can't directly prove that somebody has copied your stuff, right? You have to sort of infer it. Let me give you a really good example of how that comes about. If I go to a publisher and I say, I have this amazing idea that I am going to write a novel about the French Revolution, and I show you the first page, and it says, it was the best of times, it was the worst of times. You're like, it was the blurst of, right? Like, I'm pretty sure I've seen this before. And you would prove, right, that Tale of Two Cities, it's been published, that I've had access to it. And then you'd be like, come on, what's the likelihood that this guy just sort of independently created, a 300-page novel that word for word matches Charles Dickens' Tale of Two Cities? And a court would be like, yeah, no, that doesn't happen, right? But I mentioned the joking Tale of Two Cities part because independent creation is in fact a real thing in copyright law, right? If I independently create something that is very, very similar to a thing that you've independently created, I haven't copied your thing, right? And if I can prove that in a court of law, then we can both go ahead and sell our stuff, right? And again, I'm oversimplifying. I can't do that, right? So this is why you hear the phrase like reverse engineering, right? A patent law gives you the right to exclude other people from making, using, selling, in any way commercially taking advantage of the thing that you've patented, which again, we've described. It could be a design or it can be a process, right? And so when I own that patent right, and this is the most important thing, I don't have to be using it currently to stop you from using it, right? And so that's how patent trolls come around, right? Companies will buy up patents that are owned by defunct companies, and then they will hire bargain basement garbage lawyers to troll the internet and go, hey, I now own the patent for, a unique process for sticking a door behind a window on something. Go see if somebody is doing any of that, and then we'll sue them and we'll force them to settle and we'll make some money.
So this is the Saul Goodman.
Yes, exactly
the
right.
Saul Goodman level lawyer patent troll.
Yes, and it is very clear, right? And this gets into my you read a complaint backwards. If you look at the and I've sent you the complaint, you can make a link available in the show notes. If you look at the complaint filed by Nikola against Tesla. First thing I always do, and I tell people to do in reading a lawsuit, is you scroll to the last page, and then you got to scroll up one because there's a certificate of service. But basically, like, you go to the last page and you see who are the lawyers that represent the plaintiffs, right? And then you type that, and here it's Bayus and Willis, right? And here you type them into Google, right? And you look it up, and you see like, are these lawyers right? Does it show up? And sometimes it does, right? Sometimes they don't have websites, or sometimes you load up their website and it's like, we specialize in auto accidents, and you're like, well, why? Right. But here, this is a perfectly respectable plaintiff's firm that does intellectual property law. That's kind of your first cut of, you look at it and go, okay, this doesn't seem to be Saul Goodman, right? Like, you don't have the like big inflatable Statue of Liberty, right? It seems fine, right? And then you go backwards and you look through the counts, and here there are 5 counts, right? One is a trademark infringement, which we're not going to talk about, which basically says your Tesla is marketing this thing in a way that is confusingly similar to the way that Nikola is marketing this thing. That was not the subject of any of the motion to dismiss, right? So it is something that Tesla recognizes is at least arguable, and I think it's you look at the picture, it's pretty clear that that's arguable, right? The 4 patent claims are those 4 patents. Those counts 1, 2, 3, 4, and they're the 4 patents that I talked about, right? So 3 design patents, and then 1 process patent of how you put it together. And the way in which Tesla contested this was by filing a separate process, right? I do not want to get lost in legal minutia because your listeners will not care. But it's a process called inter partes review. And basically it allows you to go to the U.S. Patent and Trademark Office and say, hey, we recognize this party has a patent, but we want you to tell us that patent is nonsense, right? It's no good because there were other parties that did the thing before the patent was granted, right?
Right.
And this has been a part of Tesla's argument, right? Tesla's argument is, oh yeah, you claim a patent on the wraparound windshield, but like, and I've read this in the trade articles, but lots of cars have wraparound windshields. I can't speak to the process. I'm not an expert in cars. I can't think of any cars that have windshields that look either like the or the Tesla truck. But I can tell you that Tesla raised those claims before the U.S. Patent and Trade Office and lost. Right?
Huh.
They filed literally just today. The parties filed a status update. So today being May the 5th, in which the U.S. Patent Trial and Appeal Board said, we're not going to go forward with inter partes review and say that these patents are not valid because there's prior work, right? Because other people were using this beforehand. So again, that seems to be reasonably solid evidence that, like, Nikola's got an argument. And again, you could say, I think they're likely to lose, but it's not a crazy argument, right? And remember that, this is about the construction of the outside of the vehicle and the look of the vehicle and how it's all put together, and not the fuel cell versus all electric issue, right? It's just, you sort of put it up, I'm a layperson. You're the expert in transportation.
Well, it's an interesting thing.
Similar, right?
Yeah, they do look very similar. And I think, at this point, it's really difficult to try and discern what is hyperbole and what is, the general consensus here is Nikola has always been seen as a lesser company by a lot of people in this space. Not me personally. I like what Nikola's doing. I like what Tesla's doing. And I'm one of these people that goes, hey, the world is big enough for both solutions, right? I mean, and we should probably at this point haul in this kind of behavior is not unusual. We have seen companies go after rivals for patent infringement for years, as long as lawyers have been around, as long as patents have been around.
Well,
we've
and as
seen
long
this.
as billions of dollars have been at stake.
Right. I mean, you only have to look at Apple, right? We go back to Apple in the past. Apple got in trouble in the past from Xerox because, the idea of using a mouse pointer originated at Xerox, not Apple. And who came up with that idea? And was it a unique design? Did they both come up at it at the same time? Or was it because Steve Jobs happened to go to Xerox and have this demonstration and then think, oh, that's a good idea, I'll use it myself? History will decide. But we've seen this in smartphones again and again. Company A comes up with a novel idea for a smartphone, patents it. Company B comes up with an idea for a smartphone, is accused of patent infringement. Sometimes the patents are legally enforceable, and sometimes they're not. What's interesting, though, Andrew, based on what you just said, and I'm just going to apologize here, people watching this stream, obviously because of COVID, we're not in a studio. I'm recording this at my dining table, and I have chickens that I'm raising, and they're making a lot of noise over there. I will try and get rid of the chickens, not in the real world. I'm not going to dispose of them, but I will get rid of their noise in the audio for this. Going back to what you said about Tesla, instead of going directly after Nikola, they actually went after the patent. Is that a fairly common thing, this inter partes review?
Yeah. Okay. So, boy, so much that you just said that I really want to talk about. I love the rabbit trail about Apple, especially like your recollection of the Xerox Park. That was the Palo Alto Research Center. I think it was 1983, and it was the Apple versus right. Like that. That is fascinating. But whether wittingly or unwittingly, like the case that is most similar, that is the most instructive in understanding how to parse out the Tesla and Nikola lawsuit is Apple's lawsuit against Samsung, which was filed in 2012, which had to deal with the both design and which had to deal with the design patents on the Apple iPhone 3 versus the Samsung i9000 Galaxy S, right? And basically, like, we don't have enough time to go through all that rabbit trail. But if you look at the way Samsung phones were designed prior to the i9000 Galaxy S, they were very, very different. And all of a sudden, like with the Galaxy and ever since, right, they kind of look an awful lot like the iPhone, right? They got the same all black, the same sort of beveled edges. They're rounded. The icons are laid out the same way. The icons themselves are very, very similar. And Apple and Samsung suit each other across the world. And in the United States, they won with an asterisk that, having to deal with remand on some of the factual issues. But basically, in the United States, under U.S. patent law, the idea was, Apple had unique patents regarding how the screen functioned on a particular iPhone, and then how the whole thing was put together, right? So design patents, just like the wraparound windshield and the fuselage, and also a utility patent, how the whole thing is put together. And again, I'm super oversimplifying, but Apple won those lawsuits in the United States. and that is going to function. That's going to feature very, very strongly in Nikola's lawsuit against Tesla, right?
So they'll be using prior art. They'll be saying, in this case, this happened, so therefore this should happen with us. That's essentially what they're going to say.
That's right, and that is the idea that prior decisions bind courts in the future is called precedent, right? And they're going to say, like, yeah, the Supreme Court has said that the key sort of unit by which we evaluate whether a patent is valid or not encompasses both the product as a whole that's sold to the consumer, and also any individual discernible component of that product, right? So Apple here, they weren't just saying the iPhone and the Galaxy S are as a whole similar. They were saying, look, the screen is similar. The way the icons are laid out is similar, right? And that's what Nikola is saying here, right? Like they're not saying that Nikola's truck is identical to Tesla's truck, right? They're not talking at all about the internal operations, right? The hydrogen fuel cell versus the all electric. They're just saying, yeah, if we're gonna make a hybrid truck, and it's gonna have these external components that are gonna fit together in this particular way, and Tesla's kind of seems super similar to that. And that's that again. That they may lose. Like I think where this is headed, and this does not require fantastic legal judgment on my part, because there's a court order referring this to a settlement conference. But this is going to settle, right? And at some point, Tesla is going to pay Nikola a lot of money, and then have Nikola consent to license its patents to Tesla for use in the Tesla vehicle, right? Like that's where this is going, and what's going to constrain the scope of that settlement, are the legal rulings that have been pretty much uniformly won by Nikola so far, right? So Tesla won in getting the case transferred over to California, but Nikola has resisted. They won on a motion to dismiss, and they won at the U.S. Patent and Trademark Office that the appeals board is not going to challenge the underlying validity of their patents, right? And so, now Tesla can either gear up for years and years of litigation, which, if instead of it being Nikola Corporation, if it were you or I, right, that's what they would be preparing to do. They're like, all right, well, we're gonna make them spend millions of dollars on legal fees and grind them into dust. Nikola can survive that, right? They have enough venture capital that they're in it for the long haul, and Tesla's going to look at it and be like, all right, we got a judge. There's a magistrate that's appointed to handle a settlement conference, and we're going to figure out some kind of reasonable compensation that takes like the likelihood that you win a trial, multiplies that by the damages that you're seeking, which again is the $2 billion, and gives you some fraction of that.
Right.
And you should not view that as like, extortion or, nonsense or, whatever, right, or patent trolling, right? That's how 99% of lawsuits get settled in the United States.
Right. So I've got a couple of spanners to throw in the work here to kind of bring this all together. The first one is obviously the Semi came out about 7 or 8 months, I think, after Nikola first went, hey, we've got this truck. Now they'd obviously patent the idea before that. In the back of my head, my automotive brain goes, it doesn't take 7 or 8 months to go from concept drawing to here's our new vehicle. It takes a lot longer than that. And so it's conceivable. It is conceivable. And I think, and I don't know if you think that maybe the legal team might have an ability to argue this, especially if they've got their own internal documents to prove that they were working on this either as Nikola was bringing these designs to patent or concurrently with what was going on with Nikola. And I think, is there an argument there that could be made? And kind of to follow on from that, the idea of it going to settlement, is that the judge going, come on, kids, play nice?
Okay, two great questions there. So the first involves sort of speculating on facts that we don't know. Absolutely, right. Tesla's argument is going to be, because you can still raise it as an affirmative defense, even if the U.S. Patent and Trademark Office declines to invalidate the patents under inter partes review, which is what happened here. You can still raise as an affirmative defense that the patent is invalid, and that the patent is invalid because of what we call prior art, which is exactly what you said, right? Yeah. Lots of people had this windshield long before you got the patent. You shouldn't have the patent. Therefore, we're not infringing upon any actual rights.
And at the end of the day, Andrew, there's only so many ways that you can put wheels on the ground and then a chassis on top and then have somebody sitting up top. I mean, it's not like it's... I mean, they couldn't come up with it upside down. It's not like the caveman is suddenly coming along and going... I invented the chisel, and you're not allowed to use it anymore.
You know, that's true. But I will tell you, it's why Nikola has demanded a jury trial in this case. And if again, I want to make an analogy to trademark law here, because it's something we've covered on my show a bunch of times, and that the average viewer may be aware of, are the ongoing trademark battles in music, right? And trademark and copyright. Where, for example, Katy Perry won and then got reversed by an appellate court. There was the lawsuit by Spirit against Led Zeppelin regarding the creation of Stairway to Heaven. And the idea is that yes, when you're talking about intellectual property, there's only, right? There's only so many, there's a finite number of ways in which things can be assembled. But there's only a finite way of, which words can be assembled too, right? Like, right, so, it's not that distinct. And what you do is you get in front of a jury, and this is what happened in both the Katy Perry, again, those are copyright cases, they're not patent cases, they're a little different. But they played Torres's Spirit, or Spirit's Torres, I forget exactly. And it sounds like there's a bit that sounds kind of a lot like, the intro riff to Stairway. And then they introduce, the evidence that, Led Zeppelin opened for Spirit in 1967. And right. And eventually a jury was like, yeah, you know what? Lots of different ways to do music, but man, that song sounds kind of a lot like Stairway.
And that's the challenge, right? I mean, now you've got me thinking about Rob Reed's Year Zero, which, if you've not read the book, is just hilarious. It's it's narrated on Audible by John Hodgman, so it's even better. But as a music major myself, when it comes to music copyright law is a sphere unto itself.
Well, and it's an area where you get, I mean, not to go too far down the rabbit trail, but it's an area where it's easy to empathize with both sides, right? So what is super divisive in the music world is the iconic lawsuit by the Chiffons that they prevailed against George Harrison for My Sweet Lord. Right. And My Sweet Lord was found to infringe the copyright of the Chiffons' He's So Fine. And George Harrison successfully persuaded the court, right, by introducing all of his notes and background and everything, that he'd independently created My Sweet Lord. But the Chiffon, He's So Fine was number one, right? And the court was like, yeah, no, we're sure that you didn't do this intentionally. But you know what? You were listening to music in the 1960s. We're pretty sure you heard He's So Fine. We've all heard He's So Fine. And, like me coming up with it was the best of times. It was the blurst of times. But, the court was like, we think even if you didn't mean to do this on purpose, you probably, osmotically infringed upon that copyright. And you can see both sides, right? You can see George Harrison's side. He's like, I worked hard and I created this thing and it's mine and I didn't do anything intentionally. And you can see the Chiffons being like, we wrote a song and copyrighted the song, and then somebody came along and took our song and changed the team and made a whole bunch of money and didn't share that money with us, right? So,
right.
That's sort of the way in which IP works, and so it. Yes, you asked me two questions. The first question was, could Tesla argue, that the patents are invalid? Yes, they can still argue that. But Nikola will have other good arguments in front of a jury. One of them, and again, I don't know how to evaluate, this is what's pled in the complaint, but in their complaint, this paragraph 11, they say that, Nikola registers the patents in 2015. In 2016, they show the mock-ups, the picture that you just had. And then this paragraph 11 says, in September of 2016, 4 months after Nikola published its design, a recruiter for Tesla reached out to Nikola's chief engineer and tried to hire him away. Right? Said, hey, based on your background at Nikola, seems like you'd be a great fit for Tesla on our new team to focus on development of heavy trucks. Would you be open to a quick call to hear what we're up to? Now look, right? What's the basis for that allegation? Right now, the basis for that allegation is Nikola says so, right? So they could be wrong, but that could be an email, it could be a voicemail, and you think about how is a jury going to hear, at the same time that Nikola is coming out with this design, Tesla reached out to the guy who designed it, but then they say they just happened to create something that looks an awful. I'm not sure I'm going to buy that.
And we have to be really circumspect here, because I should throw in, a contextual reference in that Tesla is known to hire in talent from companies. It goes after the best of the best and brings it in. I was at the Tesla Fremont facility back in 2012 when they held the special launch event for the start of series production for the Model S, and I spoke to one of the engineers there, and he was like, yeah, Tesla hunted me down because I'd worked for this company, and they knew that I knew how to do full-length glass installations, and so they wanted me on the team. At the same point, people have been poached from Tesla by other companies. Byton has had people go to them from Tesla. Lucid has had people go to them from Tesla. The automotive and trucking world, the transportation design world, it's incredibly incestuous. And even companies are constantly collaborating. If you get enough drunk automotive journalists around a table, you play a game where you give two separate names of automakers, and you try and see who can get from automaker A to automaker B in the fewer number of steps. Who slept with who, and what was the resulting baby. I love that. And so, there's this incestuous environment in the automotive world, and we know that Tesla does go and get hire talent in, just as other automakers do. But the point here is that Tesla is currently embroiled in another court case with a Chinese firm called Xpeng, or Xiaopeng, I think is the Chinese pronunciation. I probably murdered it. Alleging that this company not only hired away one of their chief autopilot engineers, but actually that autopilot engineer stole source code and took it with them to Xpeng to work on Xpeng's autonomous vehicle technology. Now, in that instance, the engineer in question has admitted to downloading the source code, but not to necessarily take it with him when he went to work at Xpeng. And so, Tesla is going after other companies for the very thing that it's being accused of here. By Nikola.
So much to unpack there, but the process that you've described is of Tesla poaching employees from other companies is a Silicon Valley practice, right? Like it's a Google practice. It's a practice in California, and the reason has to do with a California Supreme Court opinion from about, it's almost 15 years ago now. It was about 10 years ago when I started writing about this. And it has to do with what we call covenants not to compete, right? And in 45 states, the way in which covenants not to compete work is, if I sign a contract to work for a company, that company can, under certain conditions, write into the contract restrictions on how I can work after I leave the company or am fired, right? And those restrictions are governed by what we call the legitimate business interest test. And basically, it's like, if I work for a company, selling solar panels, right? You can write in, hey, if we fire you or you quit, you can't sell solar panels to within 30 miles of where this company does business for up to 2 years after we fire you. Right, and you have to limit the scope, the 30-mile radius, and again, it's not always 30. Sometimes it's 10, sometimes it's larger, and you have to limit the time. Sometimes it's 6 months, sometimes it's a year, sometimes it's 2 years. But generally, like, lots of people are familiar with that concept of a covenant not to compete, restricting you from working in the industry, in and around where you're old, and it goes back, over 100 years. California, the Supreme Court opinion that I'm alluding to, largely held that those provisions in contracts were completely unenforceable, right? Now, does that mean you can't that does not mean you can't enforce trade secrets or customer lists, but it does mean that the California Supreme Court said, by and large, we think that broad provision that says, hey, I'm working at Google, and they put in a provision in the contract that says, if you quit or you're fired, you can't work for another technology company within 30 miles of Google, which is all of them, for a year. The California Supreme Court said, yeah, we're not going to enforce that. We're going to let you do whatever you want, because we think that by and large, that's good, not only for you, the individual employee, but also good for business, right? Because that's how startup companies hire people, right? Like, it's how Google got started. And now a startup will go to, somebody who's a middle manager at Google and be like, hey, you got 10 years working in this area. How'd you like to come to my startup and get, $100,000 in stock options, which could be worth, $1 billion someday. And that process. So the reason why this is a total rabbit trail, and sorry, we got into good law geekery, so I couldn't help it. But the reason why Tesla practices that way, and the reason why sometimes it's important to be in California rather than being in Arizona or another, has to do with the fact that certain contracts could be valid if you were in another jurisdiction, but those provisions will not be valid in California. And so, without getting into the Chinese company example, because I don't know the specifics of that case particularly well, but a major issue there is likely to be whether California law applies or some other law applies.
Right.
Because there is no, it's, again, you can't steal trade secrets, but in terms of poaching people, like, that's the Wild West in California. Again, let me look into the camera and say, this is not legal advice. If you work for a company in California, I'm not telling you, right? But in general, like, that's where the California Supreme Court is. And that practice has then, it's directly translated into business practices because of the legal ruling, which I maybe I'm the only one that finds it fascinating, but I find that super fascinating.
No, I love it. I mean, I've lived in America now for 5 years. I'm a US citizen, and it never ceases to amaze me how the different states and their legal systems all interplay and operate. And it does blow my mind. It would keep you busy for centuries. So we went down a rat hole, a really big one.
I do that.
No, it's totally fine. I listen to your podcast. So we get to the point where we are talking about the concept of, now children, don't do that again. Play nice, or
yeah. That was your second question,
right.
and the answer to that is, state courts operate. Some state courts have mandatory settlement conferences. Basically, every case that is in federal court, and this is in the United States District Court for the Northern District of California, it's a federal it's a federal trial court, right? Every court is going to push the parties in a civil lawsuit to settle those cases because we do not have enough courts, we do not have enough judges, we do not have enough resources in this country. 99% of our cases settle. And so, what happens as a lawyer is that almost nothing goes to trial. I've been practicing law for a while. For 23 years. And I've tried a handful of cases, right? And the reason is that you are disincentivized sort of at every turn to take a case to trial, including by the judge, right? And she is going to be very aggressive because her docket has 10 times 20 times as many cases as she could possibly handle. So yes, the court, and there were a couple of signs in this case, right? The first was, right, so the case was filed in May of 2018. It was removed from Arizona to California in, I believe, October of 2018. And then at the end, right, in December, right after holidays, December of 2018, the judge asked the parties if they would consent to proceed before a magistrate judge, right? And a magistrate judge is a full judge, but you can think of it as somebody who they typically don't get assigned cases off the docket. They're assigned to sort of deal with the nitty gritty of things like, discovery disputes and that sort of thing. And so, one way for a judge to move a case off her docket is to say, hey, will you let the magistrate take this? And when you say, yes, we will let the magistrate judge take this, you are, again, this is kind of a trial tip, you are effectively saying, yeah, at some point we're going to settle this case, right? We know, right, by consenting to proceed before the magistrate, we know we're going to be pushed into a settlement conference, and we know that at some point, this is just about how much money is Party B going to give to Party A. And so into 2018, parties consent to go before a magistrate. Then they litigate this motion to dismiss and the validity of the underlying patents. And now Tesla's lost on that, right? And so now what Tesla is looking at and what the magistrate is doing, right? The judge is saying, like, hey, look, you now know where this case is going to be, right? When it's first filed, you as Tesla can say, we're going to win on a motion to dismiss, and this case is worth $0 to us. Okay, well, it's going to cost us $10,000 to file a motion to dismiss. Fine. This case is worth $10,000. And Nikola can be like, we think this case is worth $2 billion. That's what we've asked for. As you narrow the legal issues, Tesla can't say this is a $10,000 case anymore, right? They can say, oh, we think we're going to go to trial and we're going to win on X, Y, and Z. And Nikola's going to be like, well, you've already spent several $100,000. You're going to spend, several $1 million getting to trial. So don't tell us this is a $10,000 case. Don't tell us this is a nonsense case. This is a serious case. And now it's a question of, can we agree on a range, right? We think we're 30% likely to win. You think you're 50% likely to win. Can we reach some accommodation in the middle? And sometimes you can't, right? Sometimes, the plaintiff thinks they're 90% to win and the defendant thinks they're 10% to win. And there's enough at stake that, you go to trial. But usually, right, and particularly when you get a judge in the room who can meet with you, he can meet with all the parties together or can meet with you separately, right? And will come in and pound on you and be like, well, I don't know, like, your judge may do X, Y, or Z, but I got to tell you, if this argument were raised before me, I would rule X. That shapes, sort of the court quite a bit, right? And look, that's super useful, right? Because I will tell you, I represent my clients. I zealously advocate for them. Every time I go into court, every time I file a pleading, I'm like, well, I think I'm 90% likely to win. Why? Because, I believe in my clients, and I believe I'm smart, and I believe in my own arguments. And, and sometimes having a judge say, Mr. Torrez, you might only be 70% likely to win. Consider that, is helpful, right? And it sort of gets the parties into the same universe. And look, like, if you can dispose of a case that is solely about money without having to pull 12 ordinary citizens off the street, and there are a lot of reasons why settlement isn't the worst thing on earth. There are reasons to dislike the U.S. Civil litigation system, and I could give you several dozen of those. but it doesn't. A settlement doesn't always mean you've wrung the last pennies out of some poor beleaguered defendant. I think that's probably a fair result here.
So we've got to a point now where we've looked at the complaint against Tesla raised by Nikola. We've looked at their patent. We've looked at the trucks, and we've gone, yeah, they kind of look similar. And I remember back when these two trucks were first revealed, or rather when Tesla's truck was first revealed, we kind of went, we've seen that before. So if we said that as industry experts, then surely someone else is going to say the same thing if it goes to jury. That could be a deciding factor for Tesla. On the other side, Tesla does have a lot more fame and a lot more fortune, and sometimes people will will side with the person they perceive as being the more virtuous of the two arguing parties. So if the defendant is someone who's given money to charity and they have led an upstanding life, even if they did the thing that they said they didn't do, they still may, and the judge will give, obviously, orders to the jury. You must not use your, preconceived ideas, and you must rely on all of the facts that are presented to you by the defense and by the prosecution, and you have to decide, based on those facts alone. But it's not how it works in the real world. And
go ahead, sorry.
And so we're at this point now where, part of me thinks it may be just down to ego, which brings us to Elon, who Elon doesn't back down. And I think this could come down to that single fact.
It could, but let me give you a completely hypothetical, right? I have zero knowledge of this. None of us do. But it is the real world application of the example that you just gave of the defendant who, well, why were you going 37 in a 25? Well, because I was, on my way to drop off food for homeless orphans, right? The way in which you really shift the way in which a jury is likely to view one of the parties. Let me offer this as a hypothetical. And again, 100% speculation. Suppose there's an email from one of the designers to, let's say, Elon Musk. Could be anybody else, but it's an email within a week of Tesla unveiling its truck. And it's one of their engineers sending an email that says, hey, Elon, boy, you notice that our truck looks an awful lot like the Nikola One? Now, if that email exists, the only party that knows about it right now is Tesla, right? Nikola doesn't know about it yet, but they will. And they get to know about that through a process called discovery. That will begin if this settlement. So this is a pre-discovery settlement conference. If it breaks down, having won on their motion to having successfully resisted a motion to dismiss, the next thing that happens is both parties get to ask for evidence from the other party. And Nikola is going to ask from Tesla and vice versa. Hey, I want all communications between any Tesla employees regarding the design of Tesla's hybrid truck, right? Alternative electric truck, right? And so Tesla's going to have to turn this document over. And again, totally hypothetical, document might not exist. And Tesla knows, and more importantly, their lawyers know right now, that they have, and they're sitting on this bad document that they have not yet turned over. And so one of the things that you do as a good lawyer representing Tesla, and again, Latham and Watkins, some of the very best lawyers in the business, making $1,500 an hour or more, one of the partners is going to pull Elon Musk aside and tell you, I get it, right? Hey, we would love to continue to represent you. We would love nothing more than to rack up $10 million in legal fees over the next 3 years while we gear up for trial. Well, let me tell you, when Nikola's lawyers hold up this piece of paper and ask you, Mr. Musk, it's true you received this email on December 2017, isn't it? And you say, yeah, that's going to look real, real bad. And it's not going to matter. You know, these are 12 ordinary people. They're not going to look at the, mechanics of how this, they're just going to look at it and be like, yeah, kind of looks like Tesla knew their design was similar and they went ahead with this anyway. Now, again, that's all. The existence of that document is speculation. But I'd be shocked if there aren't things like that Tesla and its lawyers are sitting on going like, yeah, regardless of the legal significance, this probably isn't going to look great in front of a jury.
So
and that's
we're just going to settle. Well, yeah. And, Andrew, thank you for digging through that with me over the last sort of 75 minutes. It has been fantastic.
A short dive for me.
It has been fantastic. Thank you so much. Now, just to reiterate, Andrew doesn't have any skin in this game. He doesn't have any. He doesn't have any clients involved in this. He doesn't have any connection at all to Nikola or Tesla. And the reason why I invited him on is because his podcast is fantastic. And you should all go and subscribe to Opening Arguments because it's fantastic. But also because as somebody who is in the legal profession and has an intimate understanding of how these cases work, he's very well suited to be able to say, hey, this is what this side says, this is what this side says, and if I was in that situation, here is maybe the way I would look at it. And so, Andrew, thank you so much for that.
Oh. Well, thank you for those kind words. I really appreciate that. This has been a lot of fun. I really appreciate that. And yeah, I mean, I would tell you, I have friends that have Tesla vehicles. Like if I get that. But I do think it's important to sort of evaluate both sides and take a look and kind of see, where the law is on this. And I was shocked when you brought this to my attention that the media coverage seems pretty uniformly one-sided in a way that's odd. So thank you so much for this opportunity. This was a lot of fun.
Thank you. And I think I'm with you in saying that, I would love Tesla to carry on making the Tesla Semi and not have to pay some kind of recompense to Nikola Motors for this. I don't think that's going to happen. I think your prediction that it's going to go to conference, they're going to come up with some kind of out-of-court settlement, that is probably the way it's going to go. But at the end of the day, I think Nikola are going to be tarred by people in the industry as a whole for being the company that went after, Elon, and I suspect that the comments thread for this video is going to be full of it, and so that's going to be interesting to watch and read through. But I think also it's really important to contextualize this and not just say, oh, well, Nikola say that this is copyright, because as you said, most of the people in the industry are covering this going, Nikola doesn't have a case. And so I wanted to go, hang on a second, let's get a lawyer in here and find out if they do. And I think the arguments that is these two trucks look very similar. There seems to be a case here. So, Andrew, where can people find your podcast and listen to your fantastic frolicking through the legal world.
So the podcast is Opening Arguments, and that is Open Args at most places. So it's openargs.com. We're Open Args on Twitter. It's our YouTube channel where we don't rebroadcast the episodes, but we do. We have some occasional video content and live Q&As and stuff like that. Is all Open Args. But yeah, if you look for Opening Arguments in your podcast vehicle of choice, you will find it. You start typing opening, we come up. So it's if you enjoy this kind of thing where, my co-host is a comedian and we take stories in the news that have a legal component, and I explain what the hell does a temporary restraining order mean, and how did this come about, and there are a lot of stories in the news that have a legal component these days. So
yes. With the current incumbent of Pennsylvania Avenue, I'm just going to say that it's kind of a thing.
We started the show in August of 2016, so we anticipated doing a slightly different show than we wound up doing, but it's a lot of fun, and I enjoy it, and I really appreciate the opportunity to come here and talk some law geekery, and come at me with the Tesla stuff. I'm happy if I've got something wrong, please let me know. But I feel reasonably confident in my analysis.
So there you go. Thanks very much to Andrew. I know that if you're watching this in New Zealand, it's a very different legal world in New Zealand to what we have in the United States. But I think you can appreciate that this is not a clear-cut case, as some news outlets have been portraying. And you know that we here at Ecotricity do like to try and drill down and give you the bare facts so that you really understand what's going on in the world of clean energy and transportation. I'll be back soon with more great content, but in the meantime, make sure you switch to New Zealand's only carboNZero certified renewable electricity company. I'm Nikki Gordon-Bloomfield. See you soon. Ka kite. Take care.